All right, then. What we're going to do is we're going to give each of you about a minute or so, minute and a half maybe, to sum up and give us the key takeaways for the event. And we'd like to do this in the order of the presentation of the segment. So we're going to start out with Chris Sortis. Chris, some key takeaways, please.
Sure. Thanks, Sal. So I guess first I would say that, in general, IP valuation can be complex, and it's important to have knowledge of the breadth of tools and methods at your disposal in order to arrive at the most supportable indication of fair value or fair market value, as the case may be. So I think that's an important point to consider. Secondly, I would say beware of the impact of tax reform, especially as it pertains to income-based valuation approaches, and specific to financial reporting. This is really a key change in 2018, which, all else equal, is typically resulting in increased IP values.
Thank you, Chris. Robert Vigil, some key takeaways, please.
Sure. I think we've talked about a number of things. I'd say there are two main things that I would like people to take away. First, I think it's pretty clear that increases in the amount of technology and the complexity of products that are offered in the marketplace have made valuing IP just harder. It's harder to do. It's harder to drill down, to isolate the value of individual components or contributions toward a much larger, much more complex product. That's just harder to do. And because it's harder to do, it's given rise to some new advanced methodologies that have made it easier to do that. I agree with Chris. I think sometimes these methods can be expensive. I think as time proceeds, they're more doable at a reasonable cost, but they're not always appropriate, and they're not always better. And so I think you have to look at what your circumstances to determine what's the best method to use. These methods that are available should be considered as part of the overall arsenal of methods that experts use. And with that, I'll turn it back over to Sal.
Thank you, Mr. Vigil. And finally, Armando Chavez, some key takeaways for our audience?
Yes, as far as key takeaways from the cases I discussed today, first, in the PRISM case, we heard how a settlement involving the patented technology can be useful to determine the technology's value. However, the court noted that for various reasons, a settlement may be pushed toward either being too low or too high relative to the value of the patented technology that's being valued in a later suit. Importantly, we heard that the Federal Circuit said that it's important to look at the specifics of the case and the settlement agreement itself in considering the patent value question. In the second case, we heard that apportionment of value is important in both reasonable royalty and lost profit cases, and that under the Panduit test, the CAFC found when you meet the Panduit test that the apportionment is incorporated into the analysis by its very nature, but it left open for another day as to whether other lost profit approaches would have the same impact. Last, in the Exmark case, we heard the court explain that it's essential that the reasonable royalty is based on the incremental value of the patented invention and the value that it adds to the end product. The court also noted that the experts opining on a reasonable royalty must sufficiently tie the testimony to the facts of the case and tie the proof to the footprint. You got to tie the proof of damages to the claimed invention's footprint in the market. And to conclude on, we heard that so long as Exmark had apportioned between the improved and conventional features of the accused mower, using the entire mower product as a royalty base and apportioning the value through the royalty rate was an acceptable methodology.